Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. It is a subject of great importance as far as relationship between ships, estates, navigation, transportation, etc. is concerned. I am Dr. Ashutosh Acharya, Senior Assistant Professor, Law Center 2, Faculty of Law, University of Delhi. It will be a course of 20 lectures, wherein we will talk about maritime law in detail. I have divided the course into largely two parts. The first 4 lectures largely would be talking about history a little bit, and we will talk about law of the sea. Since we are to talk about relationship between ships, sea and state, we need to understand the nuances that are surrounding the sea, the relationship of sea with a state, its usage by the state and the ship, how ship interacts with sea and how ship interacts with a state, or we may say how sea interacts with a state and ships. So, the angle of looking from the perspective of a ship, the angle of looking from the perspective of sea and from the perspective of a state, all of which will be discussed throughout this course. In this 20-hour lecture series or course, we will touch upon almost all the aspects that exist as far as laws and regulations pertaining to ships are concerned, navigation is concerned, jurisdiction and claims are concerned, insurance is concerned, pollution is concerned, environmental concerns are concerned. So, almost everything will be taken care of as far as this particular subject is concerned. Maritime law is a subject of great importance, since it is this subject which has led to development of international relations between states, especially in the modern times. But we cannot ignore the history as well, because since thousands of years, if any interaction that has taken place around the globe, that has been through sea and by using ships around the globe, be it transportation from Mediterranean world to Asian countries, from African countries to European countries, or for that matter anywhere around the globe. It is through sea route and by using ships we see that most of the transaction has taken place, and even today most of the transactions take place through sea route, and therefore it becomes one of the most important area as far as the interaction between states are concerned. And not only that, with the advent of time we have seen the importance of sea also getting developed apart from shipping, that is in the resources, the economic resources, how states want to have more and more control over the sea. And with this conflict of state, territoriality, sovereignty and the idea of common heritage of mankind, or the idea of a property belonging to everyone and not only one single state, how to resolve such, or how do we resolve such, or how have we resolved such issues in the modern times, and what has been the background of such resolutions, all of which is interconnected. And in this course I have tried through different lectures explain almost all the aspects and nuances of maritime law, of all these issues that surround maritime law, right. So, we will start with the objectives and learnings or learning outcomes of today's lecture, which is historical development of maritime law. It is necessary to understand the history of maritime law that we see today to identify the reason behind today's existence of laws and regulations. How in past we have faced different issues, different concerns, and how do we have resolved all those issues and concerns in order to reach to present legal system, present system of regulations internationally as well as nationally, because this course not only includes the international aspect, but also takes care in detail the national aspect, that is India. We will talk about Indian shipping laws, we will talk about Indian maritime law also, claims and jurisdictions as well, how India has resolved its legal system as far as pertinent challenges of maritime law, law of the sea or admiralty law are concerned. So friends, the objectives and learning outcomes for today's lecture would be to introduce law of the sea and understand its present legal regime. So not only in this lecture, but also in the coming 3 lectures, we will in detail talk about law of the sea, what is the law that takes care of governing and regulating part of the sea. So we will discuss that part, and at the same time we will talk about in today's lecture how peripherally the sovereign aspects of the law of sea exists, and in detail we will go lecture by lecture in the coming classes. Secondly, to introduce admiralty and maritime law. Friends, I have used admiralty / maritime law. Interchangeably they can be used. However, admiralty law's area or space is quite niche, wherein admiralty law largely deals with claims and jurisdictions. Maritime law is the vast area which talks about or deals with shipping laws and regulations in connection with sea or regulations of sea. Admiralty law can be considered to be part of maritime law, and at the same time at several places it can be used interchangeably as well. However, if you look at the English history, which we will also touch upon in today's class, we will see that admiralty law has been an area which has developed largely in respect to jurisdiction and claims pertaining to a particular state. So wherever aspect pertaining to jurisdiction and claim comes into being, we can say that it is part and parcel of admiralty law. And the famous terms admirals and all those terms come from this particular area of rule and regulation, that is admiralty law. Thirdly, friends, we will talk about to understand nature and historical developments in law of the sea and admiralty and maritime law. So in today's class we will discuss various historical aspects, history, European history, we will talk about Indian history, Chinese history, Roman history, how law has developed. We will talk about civil law history and common law history and their contribution as far as development of admiralty and maritime law is concerned. Therefore, this class will also equip the learners with basic importance and understanding of shipping through sea. It is also the endeavor to enable the learners understand rationale behind governance of ships. What is the reason, what is the rationale behind governing or governance of ships over sea, water, and linkage between ship, state and sea. So not only linkage, but also why linkage. So what is linkage between ship, sea and state, but we will also touch upon the aspect where we will answer the question why there is a requirement of linkage between ship, sea and state, because without interconnection, interrelationship between ship, sea and state, we cannot regulate the aspect of maritime law in totality. And therefore, there we can say that there are 3 different players as far as maritime law is concerned, that is the ship, that is the sea and the state. What are the rules and regulations that a state has to undertake as far as sea and ship is concerned? What are the rules and regulations that a ship has to undertake as far as sea as well as a state is concerned? We need to understand that interlinkage between these three bodies. Therefore, friends, starting with early development of the sea, we can identify that as the importance of sea grew, largely because of the navigational aspect. As we know that ships are largely used for navigational purposes, that is to move from one part of the territory to another part of the territory around the globe. It can be anywhere around the world. So, when such navigation is done, that is starting from one point to another point, what are the laws and regulations? When you travel into the open sea, that is high sea as we know it today, perhaps earlier or even today not much of a problem comes into being, and not much of a problem used to come earlier as well. Problem comes into being when a ship passes near to a sea area or adjacent to a sea area where there is a particular state situated. So, if a ship passes through, let us say, territory of India, then in that scenario what are the concerns of India? Or if an Indian ship for that matter passes through Chinese adjacent to passes through a sea adjacent to Chinese waters, or in South China Sea near to Philippines or any other state situated in that area, what are the concerns of those states? Can India's ship pass through those territorial waters or the waters situated near to these states or any other state? What are the rights and duties of a ship? What are the rights and duties of a state? How to regulate this interaction between the ship and the state, because ship is belonging to some other state and the water is near to a particular state. The potential concerns that can come into being and that have come into being in the past also, raised by the states also, are largely with respect to security. That a ship may be prejudicial to the interest of the coastal state. When, if the state feels that a particular ship passing through its waters is prejudicial to the interest of the state, then in that scenario, what are the measures that a state can take? If it is not prejudicial to the interest of the coastal state, even then can the state have its control over sea area? It has a significant historical aspect that we will talk about today. Now, taking into account these two aspects, one is with respect to ship, because ship wants to navigate. Another one is with respect to state. A state might be apprehensive of any ship belonging to any other state or not belonging to any state passing through its coastal areas. State's concern would be largely based on security concerns, and therefore, when these two concerns collide, what is the solution to these concerns? Historically, two ideas have come into being, and these two ideas are quite extreme in their own nature. One of the idea that was propounded in 17th century comes from a Dutchman known as Hugo Grotius. Friends, Hugo Grotius is considered to be father of international law. He has lived from 1583 to 1645, and he propounded the theory, the idea, the concept of mare liberum in 1609. What is mare liberum? Mare means sea, or you can say water. Liberum here means liberty. So, he propounded the idea or concept of liberty of sea, or you can say freedom of sea, from which comes the idea of freedom of navigation. That is, a ship has the right to navigate from one part of the world to another part of the world and should not be restricted. That is, the navigation of a ship should not be restricted by any coastal state. All ships have the right to navigate from one part of the world to another part of the world, irrespective of the fact that it crosses through the coastal waters of a particular coastal state. For example, if a ship crosses, or if an Italian ship crosses English waters, according to this idea, the English authorities or England should not prohibit, should not restrict the navigation of that particular ship. So, the extreme approach to this particular idea would be that even if the ship is, let us say, prejudicial to the interest of England in the given example or in the said example, then the English authorities cannot take any action against that particular ship. If let us say a ship has halted for no reason near English waters, the English authorities, as per this concept, as per this idea, will not be in a position to question the ship, to investigate or to take jurisdiction over that particular ship, or to take any measure against that particular ship. Freedom of navigation, the extreme approach of such particular concept would be that the coastal state cannot interfere into the ship. Another extreme approach would be traditionally, word of caution that I am not talking about the legal scenario that exists today, just an extreme approach of another idea given by an Englishman Selden, known as mare clausum in 1635, which is opposite to mare liberum, which says that there must not be liberty of sea, rather there can be sovereign rights over the sea by the state, and when there are sovereign rights by the state over the sea, certainly friends, any ship passing through those sovereign waters, its navigation or its route can be restricted, can be disturbed, can be hindered with. So, both the theories are giving preference to two different aspects. Mare clausum gives preference to states and state rights. At the same time, mare liberum gives preference to navigational rights of ships. So, in order to reach to a middle path, we can see in today's time that a compromise has been reached. The right to navigation, freedom of navigation has been recognized. However, at the same time, rights of a state in a restricted manner has also been recognized. Corresponding or corollary rights and duties have been endowed upon the ship as well as the state. The state has certain rights and duties with respect to ship, at the same time the ship is also having certain rights and duties as against the state. So, a quite simple, or you can say quite a smooth, clear, objective approach has been taken as far as modern laws and regulations pertaining to freedom of navigation is concerned. So, in general, if I may concretize the today's modern law, which is a confluence of both the ideas, that is mare liberum and mare clausum, we can say that there is existence of freedom of navigation, that is a ship can sail from one part of the land to another part of the land in the globe, but it must not act prejudicially, or it must not be prejudicial to the interest of the coastal state. That is, for example, it must not act in such a manner that affects the safety concerns of a coastal state. So, a ship has the right, but it is subject to certain limitation which takes care of the interest of the coastal state. We will discuss that also in detail as far as present law is concerned in the upcoming classes. In 19th century, we see rules of customary and treaty law as an answer to natural law got developed. We also see in 19th century that positivism had started making its mark. Not only in France or England or in any other positivist country, but internationally also. Internationally, we see that efforts were made by international community through different institutions, through different international bodies to prepare codified laws, to prepare codified rules and regulations by which different states, ships and sea can be governed. Because if I take you back 14th century, 15th century or even before that, we can see how different national territories have come up developing their own rules and regulations, who believed that sea should be governed by the state, where states believed that sea should not be governed by state, they believed in the idea of mare liberum, freedom of navigation completely. France was one of the proponent of freedom of navigation, not controlling the sea area adjacent to its territory. However, at the same time, English approach has been little different as far as the controlling part of the sea is concerned, and because of this reason we see certain practices getting developed. One of the practice, let us say for example, would be cannon shot rule, another would be eyesight rule, wherein the English approach was that up to whatever extent or up to whatever breadth a cannon can be shot, up to that extent sovereign aspects of English waters or English territory would lie, because it is up to that region or up to that mark the English waters can be protected. So, if any ship is found to be acting prejudicial to the interest of English coastline or English state or England for that matter or British territory, then in that scenario it could take certain measures against that particular ship, thereby hindering the freedom of navigation part. So, the preference to state rights over ships has been a constituent approach as far as English approach has been concerned. Friends, moving further, if we look at the codification part, we can also see that the origin of law of the sea or laws pertaining to ships has been the same origin, or the origin are same as far as public international law is concerned or as far as maritime law is concerned. So, generally anywhere wherever international law or its constituent part comes into being, the sources remain the same. So, when we talk about positivism, when we talk about codification, certainly international treaties, international conventions, covenants are something which comes up as an international agreement which becomes binding on the states that agree or consent to that particular international treaty or a convention for that matter. So, under public international law, if treaty or a convention is a part of positivism where it acts as the point of origin for international law to develop, then for maritime law as well as for law of the sea, positivism has been one of the originating point as far as international law of the sea or international maritime law is concerned. Even in domestic legal systems around the globe, within the states also, positivism has played a significant role, or codification has played a significant role as far as development of maritime law, shipping law, etc. is concerned. So, when we talk about the origin or the source of maritime law, we will see it is the same source that we see for public international law. So, if you look at the sources part, we can look at Article 38, Clause 1 and Clause 2 of the Statute of International Court of Justice. The Statute of International Court of Justice, Article 38, Clause 1 and 2 specifically identifies what can be the sources or point of origin of international law in general. Since law of the sea and shipping law are part and parcel of international transaction or international legal transaction, the same sources would be also used as far as the subject is concerned. Therefore, if you look at the statute of ICJ, Article 38, Clause 1 identifies 4 sources of international law under Clause A, B, C and D. Clause A talks about international conventions, whether general or particular, establishing rules expressly recognized by the contracting states. So, friends, international conventions, for example, United Nations Convention on Law of the Sea, Geneva Convention on Territorial Waters or Territorial Sea, Geneva Convention on Continental Shelf 1958, or for that matter any other convention or treaty signed between these states would act as one of the primary source of law of the sea or maritime law in general. If any treaty is signed between two states with respect to division of their continental shelf, then that particular treaty acts as the primary source of any dispute that may arise between two states before the international court or international tribunal or any other international adjudicating body. This international convention may be general or particular. When it is general, it is applicable almost on all the states. When it is particular, it may be between certain states. Second source of modern law of the sea would be international custom as evidence of a general practice accepted as law. Friends, international custom has two requirements to be fulfilled in order to culminate into international custom. How international custom is made, how international custom is framed. As compared to international conventions, international custom is not that certain, is not that objective in nature, since it is not codified. So, therefore, it is not found in written words as such. However, it may be if a particular provision of a convention has transformed into a general practice around the globe and there is widespread acceptance qualitatively as well as quantitatively, we can say that that particular written provision has transformed into customary rule of international law as propounded and enunciated in North Sea continental shelf cases. At the same time, if there is no provision which has transformed itself into customary rule of international law, there is merely a practice, there is no codified provision, there is merely a practice amongst states, between states, which is in question that whether it is international custom or not an international custom. Then when this question is raised before the court will then identify that whether a particular practice between two states or more than two states in general or in particular has been so accepted to such an extent that it can now be called as international custom. Friends, another practice that we see getting developed throughout these years and now has been codified is with respect to freedom of navigation. As we see, the idea was given by or was first concretized by Hugo Grotius under the idea of mare liberum. Freedom of navigation is a practice that comes up as a necessity out of the state, because almost all the states want to navigate from one part of the territory to another part of the territory, either for fishing or for transportation largely, to establish international relations, trade relations and any other type of relation. Then in such a scenario, out of necessity we can say that states want to allow other ships also, so that in reciprocity other states will allow their ship. So, based on consent, based on reciprocity, which forms the basis of international law, we see that freedom of navigation is a necessary legal requirement and therefore states have recognized. So, since there is uniform universal practice with respect to navigation, we can say that it has developed as an international custom. So, we see, friends, that international custom can be a great source of modern law of the sea. The requirement that international custom has is or are the material facts, that is the actual conduct, and the subjective part, that is the psychological element, which is known as opinio juris, which comes up from opinio juris sive necessitatis. Opinio juris, friends, here would mean in the opinion of the law, that states have the belief, states have the conviction to follow a particular practice. Once the court is satisfied that states have the conviction along with the conduct, along with the practice that we have seen, then the court can confirm, the court can conclude that yes, this particular practice, be it freedom of navigation, flag state jurisdiction or any other kind of practice, has culminated itself into international custom. And when any particular practice is identified to be an international custom, then we can say, friends, that it is now international custom binding upon all the states. Friends, it may be divided into two further parts, that is local custom and regional custom. When such international custom is between two states, it may be called as local custom. For example, right to free passage case or right to passage case between Portugal and India. It was certainly with respect to freedom of navigation, where also the court recognized the Portuguese right of navigation. At the same time, it also could not ignore the right of India, that is the coastal state, as far as its security safety concerns were concerned. So, both the rights were recognized. We also see regional custom coming into being. It may be with respect to a particular region where states are geographically adjacent to each other, situated near to a sea, and if they have certain custom developed amongst themselves, then that could be a regional custom. Apart from that, apart from these two primary sources, we have another important source of modern law of the sea, and that would be general principles of law recognized by civilized nations. Friends, there are various principles recognized by civilized nations, such as principle of acquiescence, principle of equity, and certain other principles. These are certain principles which are applicable and recognized within the domestic legal system of different states. If equity, for example, is a principle applicable in the domestic legal system of different states, then it becomes a general principle, because it is a principle generally followed amongst civilized states or law abiding states. Then we can say that that particular principle can be used in order to resolve a dispute between two states. For example, friends, we see that proportionality equitable principle was suggested by the International Court of Justice between dispute of Germany and Netherlands and Denmark. So, in North Sea continental shelf cases, we see that this particular general principle was suggested by the court to be utilized in order to resolve dispute between these three states, that is Germany versus Netherlands and Denmark. There are other principles also which are generally accepted by the states and can be used as far as dispute between different states are concerned pertaining to law of the sea or maritime law. The fourth source of modern law of the sea would be judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determinations of rules of law. Friends, apart from the three primary sources of international law, we have the fourth subsidiary means of source of modern law of the sea, also international law, where if there is absence of any convention or a treaty, where there is absence of custom to be applicable in order to resolve a dispute, or any general principle is also not found to be applicable, then in such a scenario judicial decisions can be of certain persuasive value and can be helpful to resolve a particular dispute placed before international adjudicating body. Well, friends, as far as convention, treaties or codification are concerned, there have been certain attempts to codify as far as international law of the sea or maritime law is concerned. Well, friends, if you look at 19th century approach and 20th century approach, you will see that International Law Association had produced several reports and held lengthy discussions on various topics such as territorial waters, marine pollution, the seabed and its resources, international waterways, deep seabed mining, piracy and port jurisdiction. So, we identify that on different subject matters, on different areas, International Law Association had produced several reports which were healthy and which were useful in future deliberations, in future discussions and future codifications as well. Committee of experts was formed by League of Nations in 1924. It drew list of subjects which were ripe for codification. Territorial waters, since it was one of the important subject matter amongst the states, because states were by 20th century apprehensive of other states that if any ship comes near to their coastline, it may be prejudicial to the interest of their safety and security, because many a times in the past this has happened, wherein ships crossing through or ships crossing near to your coastline were warships or were army ships or naval ships, wherein at the end of the day they ended up entering into your territory and taking over forcefully that particular territorial region. So, in order to protect one's territory, states were quite inclined in order to create the regime of territorial waters. That is, once legal regime of territorial water is created, it will provide certain rights to coastal state where they can restrict the idea of freedom of navigation to certain extent, largely to protect their concerns pertaining to security and safety. Therefore, territorial waters concern pending for a longer period of time was now opportune or was now ripe or ready to be codified, so that there is universal and uniform rules and regulations available and present for the states to be implemented. Well friends, we must also note that there were different approaches with respect to extension of territorial waters. The breadth of territorial waters, what should be the breadth of territorial water, up to what extent the state should have sovereign rights, territorial rights as far as sea water is concerned. So, in order to universalize this particular aspect, the states were coming together, sitting together, having discussions, and were trying to come up with one single answer. Piracy had been a problem since thousands of years. States or state transportation cannot take place or will be prejudicially affected or will be adversely affected, you can say, will be negatively affected if piracy prevails. No safe commutation, transportation can take place without removing the pirates or without taking away the evil of piracy. So, if peaceful transportation has to take place, piracy has to be tackled or taken care of, and for that states require cooperation. Without cooperation amongst states, we cannot take care of piracy. And therefore, this was another important area where codification was required. Then exploitation of marine resources. By the advent of 20th century, friends, we see that states had substantially developed as far as technology and science is concerned. States, especially the developed states, the advanced states, had developed their technology to such an extent that they could now extract resources from sea. Of course, they had resources on land, but assume a situation, assume an area which is more than double the land surface area, since the land surface only is composed of 30% of the total globe, that is earth or of the planet. 70% of the region comes under sea water. Assume a situation where abundance of resources is available. So, that was another concern which was more economical as compared to safety and security. So, states' interest not only with respect to safety and security is now an important issue, but 100 years before or 100 years from today, what happened and what will happen, the scientific development is progressing to such an extent that the economic importance of sea becomes one of the important area to be taken care of as far as codification was concerned. The states now required universal uniform rules and regulations with respect to exploitation of sea resources. The states require uniform rules and regulations largely because there is difference between the economic standards, the scientific knowledge of different states. The state having more scientific knowledge would be in a better position to extract more resources. The states not having scientific advancement would be in a disadvantageous position to extract resources from sea. At the end of the day, one who is at a better position would be ending up at a much more better position. So, the approach towards this economic equitability changed post Second World War. We will discuss in brief that also, but prior to Second World War we see existence of colonization, and therefore, it were only largely the advanced states who were part and parcel of the discussions and deliberations as far as exploitation of marine resources were concerned. So, the interest of certain states, especially in 1924, but post Second World War we see the interest of the non-advanced or the states who just got decolonized was also discussed and deliberated upon, especially at UNCLOS 1, first conference on law of the sea, then second conference and the third conference, right friends. And it also drew up a list with respect to making law on the legal status of state owned merchant ships who were among the subjects considered. Subsequently, a preparatory commission was set up to draft codes on nationality, state responsibility and territorial waters, referred the draft articles to governments in hope that agreement could be reached at some later point of time. Finally, we see in 1948, post Second World War, International Law Commission formed the basis of first conference, that is United Nations Convention on Law of the Sea 1. Friends, we will now look at the important areas of UNCLOS 1, 2 and 3. But before we do that, let me give you a brief idea of how different regions exist as far as the sea water is concerned. So, let us say this is the land portion, let us say this is the sea area in front of the land portion. The traditional idea has been to create a region of territorial waters or sea, which will be directly attached to from the land surface up to a certain point. In modern times or under modern law, it is largely 12 nautical miles, extending from the point of land area up to 12 nautical mile. The water column would be, or seabed or the airspace above would be known as territorial sea. So, up to 12 nautical mile you have territorial sea. Traditionally, if I say from this point, that is where the territorial water ends, up to certain point, I am not specifying it right now, but since I am talking about traditional approach, up to certain point the sea area would be known as continental shelf. The continental shelf is the area which is of economic importance. At the same time, the territorial water has strategic as well as safety and security interest. So, security interest, safety interest and strategic interest are the concerns with respect to territorial waters, and beyond that it is economic interest. But in modern times we have two more additions as far as the distribution is concerned, and they would be contiguous zone starting from land surface up to 24 nautical mile, it would be contiguous zone. The point where territorial sea ends and up to, so from here land surface to 12 nautical mile, it would be territorial sea, and from this point, that is from where the territorial sea starts, that is the land area, up to 24 nautical mile. So, territorial sea here is overlapping with your contiguous zone. So, for 12 nautical mile there is overlapping, but post 12 nautical mile, the next 12 nautical mile would be only contiguous zone. However, at the same time it has overlapping with another concept which comes up only with United Nations Convention Law of the Sea, that would be exclusive economic zone known as EEZ. Friends, we will discuss this in detail in the upcoming class, just for an introduction mentioning these terms. So, under UNCLOS we have now EEZ, and therefore, this EEZ is starting from the point land surface up to 200 nautical miles, a state can have exclusive economic zone. So, this will focus specifically on the economic aspect, and then you have your continental shelf. What are the rules pertaining to continental shelf? All of will be discussed in the upcoming class, and when all of this comes to an end, continental shelf and EEZ, you have your high seas, which belongs to no sovereign aspect, either economic sovereign aspect or territorial sovereign aspect or any other kind of sovereign aspect. So, getting abreast about these terms as far as sea area is concerned, let us go through the historical developments that took place post Second World War, or you can say mid 20th century. In 1958, UNCLOS 1, it adopted 4 conventions on territorial sea, which was known as Geneva Convention on Territorial Sea 1958, and then contiguous zone, Geneva Convention on Contiguous Zone, then Geneva Convention on High Seas, Geneva Convention on Continental Shelf, and Fishing and Conservation of Living Resources of High Seas respectively. The first 3 conventions were ratified by substantial number of states as they came out of the generally accepted rules of the law of the sea, whereas the 4th convention saw poor response due to the fact that it went ahead of the existing obligations which customary law imposed on states. In UNCLOS 2, 1960, we see it discussed breadth of the territorial sea, as we see, as I told you, that in today's time it is 12 nautical mile, but in 1958 it was already under discussion that, or in 1960 it was already under discussion that what should be the breadth of territorial sea. It is only in 1982 that 12 nautical mile got finalized post 3rd conference. Then, so they discussed the breadth of the territorial sea in 1960, fishery limits, proposed a compromise formula of 6 mile territorial sea plus 6 mile fishery zone. However, it failed by 1 vote. UNCLOS 3 in 1967 discussed origin in seabed committee established by UNGA to examine the question of deep seabed lying beyond the limits of national jurisdiction, that is beyond the continental shelf. As I told you, the economic importance of the sea was rising significantly with the advent of scientific and technological advancement. So, deep seabed mining, extracting resources from sea, largely you can say a certain amount of minerals, elements as well as oil from sea, extraction of these resources was now the concern of the state as far as sea area was concerned, apart from transportation and navigation and fishing, where sea acting as food resources and route is concerned. So, this was an additional benefit, the most important benefit that a state realized. So, especially the advanced states wanted to have deliberation and discussion on that particular part, that is largely deep seabed mining. What about the area which does not fall in the sovereign rights of the state? What about the high seas? So, they required certain rules and regulations in order to govern and regulate that particular area as well, that is high seas. UNCLOS 3 held its first session in 1973. The conference was divided into 3 main committees. The committee to deal with problem of legal regime of the deep sea bed, second to deal with the regime of territorial sea and contiguous zone, the continental shelf, exclusive economic zone, the high seas, and fishing and conservation of the living resources in high seas, states and archipelagic states. Third, to deal with the question of preserving marine environment and scientific research, group 77. And then in 1982, we see UNCLOS coming into being. International Maritime Organization has played a significant role as far as codification and formalization of maritime law and law of the sea is concerned. Until 1982, it was known as IMCO, Intergovernmental Maritime Consultative Organization, wide competence in matters affecting shipping, and has adopted a detailed and technical approach to its work. All of the shipping laws, international in nature largely, we will see has been codified, drafted by International Maritime Organization, which is a specialized agency of United Nations organization. Its committees such as Maritime Safety Committee, Legal Committee and Marine Environmental Pollution Committee have played prominent role in drawing up regulations concerning pollution as well as navigation. Friends, apart from the law of the sea, we will now come on to the historical aspect of the ship, especially with respect to claims and jurisdiction. So, what has been the history as far as jurisdiction is concerned? So, once sovereign rights are established, once a particular ship is to be tried under the jurisdiction of a foreign court or before the foreign court, or if the ship of the same court of the same belonging to the same state, or let us say English ship is to tried before the English court, or if the French ship is to be tried before the English court or vice versa. What are the rules pertaining to jurisdiction? What is its historical development? What has been its historical development? We will now touch upon all those aspects starting from ancient times. We will also touch upon the Indian approach, Indian history as far as admiralty law is concerned. So, in ancient times we see a great deal of trade transaction used to take place between India and Europe, though it was not direct, but changed hands at bulk, Aden or Palmyra. This can be established through certain evidences, written evidences by different navigators that travelled from other parts of the world to this part of the world, from this part of the world to that part of the world. There was lack of writing instruments, and therefore, we have dearth of recordings, we have dearth of written documents which establish at a wider range that who travelled, when travelled, but yes, there are certain excerpts and there are certain smaller evidences available even today, which shows that when discovery of this land as claimed made in the medieval times was made, the discovery was certainly not made in only in the medieval times, but earlier also in ancient times also we see that there were ships that could travel from one port to another port, and slowly there was certain transaction that used to take place. And therefore, we see that sometimes when we see that goods travelled from India were also bartered for some other goods, which led to inaccuracy and vagueness of accounts, changing the story as it passed through various hands in the West. If you look at Indian approach, we see that in Rig Veda it has been mentioned that Indian sailors were inexperienced ones. This can be evidenced from early Indian literature that contains abundant references to ships and contains testimony to seafaring skills of Hindu mariners. Indian ships in early times were much advanced, and there is mention about a ship as large as having 100 oars and could carry 700 people that marched through distant islands and galleys. Maritime activities in India can be traced back to Indus Valley civilization, dating as far as 4500 BC as it extends in time. It can also be traced in terms of coverage as it extended to islands of Indonesia in the east and islands of Japan in the north. Traces of art and culture depict evidence of the fact that transaction through sea route existed as the cheapest and safest mode of transport. In the ancient times existed guilds that offered functions of combined set of skills. Guilds included a combination of a trade union, democratic government, a technological institution and a court of justice. Guilds were entrusted with the task of framing rules for smooth transaction of trade and commerce. Sarthavaha or Sreni Pramukha are the titles used for the head of the guild. His task was to ensure formulation of rules for a proper conduct of trade. If you look at Greek connection, in 45 AD it was discovered by a Greek captain named Hippalus that the distance from Alexandria to western India can be covered in 40 days through monsoon winds. This tremendously increased Roman sea trade due to the shortening of the route. An anonymous merchant has noted in the Periplus of Erythraean Sea that seaports of South India were the most flourishing ones. He speaks of various ports, namely Kaveri Paddinam, Nalkainda, Negapattanam, Kodikaraim, Sopatma, Kolchi or Korkai, Poduka and Kamara. There are evidences that tell us that around 2500 BC, world's first tidal dock was built at Lothal during the Harappan civilization. Indus Valley civilization had many other smaller ports, possibly at Dwarka and Balakot, now in Gujarat. Ships from these ports established maritime trade with Mesopotamia. An interesting incident in this regard is worth mentioning, as during the times of King Ptolemy VIII of Greece, a shipwrecked Indian sailor was discovered by the coast guards at Red Sea, who was half dead. The Indian sailor, in order to return the favour, asked the king to send any of his navigator and he shall show him the route to India, and thus the route to India came to be known, resulting into trade relations between Indian states and Greece. These ports were owned by one or the other of three important Tamil kings, Kolchi or Korkai, whose pearl fisheries were carried on a large scale, belonged to the Pandyan kingdom. Kamara, Poduka and Sopatma were Sola ports. Kodikarai, Nagapattanam and Kavari Padinam also belonged to the Cholas, while Musiri and Nelkinda were the ports of Chera kings. These various South Indian ports, favorably situated as they were, facilitated South Indian trade with the rest of the world in the prehistoric and later ages. If you look at Roman connection, friends, Nicholas of Damascus has noted that an Indian delegation from Pandyan or Pandya dynasty visited King Augustus at Antioch in 13th BC. King Augustus established trade relations with these South Indian dynasty, which was later opposed to by the Senate of King Augustus, as the cotton clothing in Toba that is imported was too expensive, causing trade imbalance. We also have Mauryan Empire's transaction. The empire can be considered to have the oldest reference of organized maritime transactions and establishment. The word navigation is believed to be derived from a Sanskrit word Navagat. It is also believed that the science of navigation originated during the times of Indus Valley civilization at Indus River some 5000 years ago. Arthashastra by Kautilya, who was the prime minister in court of King Chandragupta Maurya during the Mauryan period, mentions a full chapter on the State Department of Waterways under Navadhyaksha, superintendent of ships. Moreover, the term Nava Vipantragamanam, that is sailing to other lands by ships, also appears in his book. According to the information supplied by Kautilya supplementing Megasthenes, considerable, there used to be a board of shipping and a port commissioner that would supervise sea, river traffic and ferries. Ferries were in the hands of government and tax was collected from merchants, fishermen and travellers. Pickets used to guard ports, preventing any suspect from entering or leaving the port. Providing assistance to a ship's distress was the duty assigned to harbour master. Hegel has said, India as a land of desire formed an essential element in general history. From the most ancient times downwards, all nations have directed their wishes and longings to gaining access to the treasures of this land of marvels, the most costly which the earth presents, treasures of nature, pearls, diamonds, perfumes, rose essences, lions, elephants, etc., as also treasures of wisdom. The way by which these treasures have passed to the West has at all times been a matter of world historical importance, bound up with the fate of nations. We also have British era or medieval times, where we see different developments coming into being. The important ones that we can identify are with respect to the coming up of Black Book of Admiralty, and then post Black Book of Admiralty we have in Napoleonic Code coming into being, which resulted into different codes getting developed, Admiralty laws coming into being, Admiralty Codes Act coming into being 1840, and various other acts coming into being. And then we also have Indian implementation as far as Admiralty law is concerned by the Britishers, and then we also have Indian approach post independence as far as the maritime law or Admiralty law is concerned. So friends, I would appreciate your patient listening. Namaskar, thank you. We will continue with this in the next class.